This case has been a long struggle for the Okie community. We have been in the court, several courts in Kenya for the last 20 years, but we have never get justice.
When human rights violations occur, international courts and other bodies can order reparations. That is, an act or process of making amends for a wrong to the victims, as well as preventing further violations occurring. But the path to helping right a wrong is not always straightforward. All too often, justice is undermined by a lack of adequate mechanisms to implement reparations. I'm Rachel Murray, and with Deborah Long and Franz Villian, our research is focused on enhancing the delivery of reparations to victims of human rights violations. We looked at reparation decisions from international human rights bodies that called upon state authorities to remedy international human rights violations. This included instructions such as payment of compensation, releasing individuals from detention, and adopting legislation. We traced individual cases of human rights violation across 9 countries. In each of the states, we followed cases through pre-decision and judgment, the decision and judgment itself, and then what happened post-judgment, including actions taken by the state authorities, if any. For example, an important judgment won redress for the Ogiek people, an indigenous people living in Kenya's Mau forest. We provided a briefing to the African court regarding how best to ensure redress for the Ogiek people, which was adopted in the court's ruling against the Kenyan government. This included effective monitoring of implementation, including the court's specification of remedies, timeframes, and the requirement for a compliance hearing. These are now directly contributing to restoration of the Ogiek's land and to compensation of 157 million Kenyan shillings, which is just over 1 million UK pounds.
Rachel was helpful when I was drafting some of the arguments and also particularly looking at the remedies that the Ogiek wanted to seek. We wanted to make sure that there was a clearly defined ruling that made very specific steps that the Kenyan government would have to take. Issues such as return of ancestrally owned land, payment of compensation, but also going to steps to kind of prevent these violations recurring. So change in legislation, change in policy, identification and recognition of the Ogiek.
Our recommendations have been incorporated into the African Court's strategy for monitoring state responses and helped address cases where reparations had not been implemented after rulings. Since then, over 60 judgments have benefited from this change. Another example is the people of Kilwa of the Democratic Republic of Congo, where over 70 people were massacred. Our work on developing a strategy with the Institute for Human Rights and Development in Africa is helping to ensure that the families of the victims are granted compensation of over $2.5 million. The Institute now uses this strategy as a roadmap in other cases and in dialogue with states.
We were lucky to have Rachel on our board because Rachel has worked on enforcement of decisions of supranational institutions for so many years. So she was kind enough to volunteer to help us develop guidelines on how we approach implementation or enforcement for cases. Now that organization has a document that guides its everyday work, making sure whatever order is issued by any of the mechanisms in Africa are complied with.
I'm so proud that our research is bringing the delivery of reparations to the fore and ensuring victims of human rights violations in African states are delivered due justice.